A lawsuit brought by craft chain Hobby Lobby is one of the most anticipated cases of this U.S. Supreme Court term. Hobby Lobby Corporation, owned by the Green family of Oklahoma City, claims its owner's religious beliefs should prevent it from making some birth control products available in its employee health plans. Legal scholars believe the case will have a significant effect on civil rights and labor laws and the First Amendment. Hobby Lobby has grown from one store in 1972 to 561 stores in 39 states and has sales of more than $2 billion each year. The corporation employs 28,000 people. Hobby Lobby was founded by Oklahoma City residents David and Barbara Green. The Green family is devoutly religious and objects to a certain mandate in the Affordable Care Act. The ACA provides that birth control be made available to women at no cost from private insurance providers. Of the 20 approved birth control products, the Greens object to 4, 2 intrauterine devices and 2 birth control pills they believe induce abortions.
This is an issue of life that we cannot be a part of taking life. And so to be in a situation where our government is telling us that we have to be is incredible.
And there's no way we're taking anybody's rights away. It's our rights that are being infringed upon to require us to do something that's against our conscience.
Hobby Lobby is suing Secretary of Human Services Kathleen Sebelius, claiming the company shouldn't have to provide insurance coverage for the IUDs and the birth control pills, Plan B and Ella. The Greens believe life begins at conception. In this video statement, Barbara Green explains why they're suing the federal government.
Our family started Hobby Lobby, built on our faith, and as a family together. We've kept that tradition for more than 40 years, and we want to continue to live out our faith in the way we do business. The choice that the government has forced on us is unfair and not in keeping with the history of our great nation founded on religious freedom. We believe that Americans don't lose their religious freedom when they open a family business.
The U.S. Supreme Court heard oral arguments in the case on March 25th. Justices interrupted Hobby Lobby attorney Paul Clement several times.
Blood transfusions?
The blood transfusions, again, each one of these cases I think would have to be evaluated on its own and apply the compelling interest, least restrictive alternative test and the substantial burden.
So really every medical treatment, and Justice Sotomayor is quite right, that there are quite a number of medical treatments that different religious groups object to. So one religious group could opt out of this, and another religious group could opt out of that, and everything would be piecemeal, and nothing would be uniform.
The ramifications are a very serious concern.
University of Tulsa law professor Marguerite Chapman is a medical law and bioethics expert.
If you think about medical products, we have medical products made from pork, we have medical products made from cows, bovine valves for heart patients, for example. You may have someone who's Hindu who would object to who owns a large company who would object to having health coverage that would include providing valve replacements if they were made from one of these religiously forbidden products.
Chapman and law professors Tamara Piety and Vicki Lemus are following the Hobby Lobby case closely because so many issues are at stake. Piety specializes in First Amendment law.
The ramifications of saying that a corporate person is exactly the same as a natural person and has all the same rights would be so widespread. They would attach to things like right to remain silent, which currently corporations don't have, and some other rights that I don't think that the court's going to say that.
Hobby Lobby attorney Paul Clement.
It may first blush seem like, there's something odd about a corporation exercising religion, but a lot of people are familiar with something like Chick-fil-A. And if you try to get a Chick-fil-A sandwich on a Sunday, you have a problem because they're closed on Sunday.
Chick-fil-A doesn't ask people what their religion is before they sell a chicken sandwich to them. They're really in the chicken sandwich business. And I think Hobby Lobby is really in the craft business. It's not really in the proselytizing religion business. It's not the Church of Hobby Lobby.
Lemus is an employment law expert. She believes the Supreme Court's decision could have a profound effect on employee rights. Lemus says a ruling in Hobby Lobby's favor could be in direct conflict with Title VII of the Civil Rights Act of 1964.
Meaning that an employer can't impose his or her religious beliefs, a private employer can't impose his or her religious beliefs on his or her employees if the employees object, if those beliefs are not compatible with the employee's own religious beliefs, which includes non-belief. To me, it would appear then that an employer could take the position that, well, because of my religious beliefs, I'm not going to hire anyone who's openly gay. And my religious beliefs would insulate me from having to comply with a state law that protects those individuals in the workplace.
Chapman says the ACA gives Hobby Lobby another option, but it's one the corporation rejects.
With the Affordable Care Act, Hobby Lobby could choose not to provide health care coverage, pay a tax. The tax would be about $2,000 per employee using a certain formula that's applied, which would mean, I think, about $26 million per year in terms of the cost, I think, to Hobby Lobby. That money would go to help subsidize the exchanges. And so these employees who would not get coverage from Hobby Lobby could go to the exchanges and get coverage that way.
The Supreme Court is not expected to issue a decision until June. Court observers believe the case could go either way.
The justices seem deeply skeptical of the government's arguments that Americans who open a closely held family business give up their right to religious freedom and can be subject to whatever the government mandates that they do.